What is my philosophy when representing a client in a civil litigation? I think for me, to sum it up, is to be relentless. It doesn't mean sort of creating issues where none exist, or to utilize a trademark term of a local attorney of aggravated litigation and, trying to make everybody miserable. But it's that we're here, we filed a lawsuit, or we've been sued, we have to deal with this. Why do we let it linger? If we can push it along as much as possible, I find that it's in my client's best interest. So what does being relentless actually look like or mean in this context? So first and foremost, it's on the discovery side. We push to get the discovery that we want and that we are entitled to, and try to get it done as quickly as possible. I mean, sending out document requests early, sending out some interrogatories, but mostly I want to see what the documentary record shows. I find that that's going to much more shape the ultimate testimony in the case than sort of the lawyers going back and forth with questions and sort of cryptic answers, which is what you often get out of interrogatories. So we try to limit our interrogatories to very specific or precise issues that we want a specific position, so we know if that's something that has to be explored or not. But then what often happens is you get 60%, 70%, of a response. And a lot of lawyers, in my experience, leave it at that. Or maybe eventually 6 months down the road, they come back and go, hey, where's the rest of this stuff? And I find that that's not an effective way to sort of push a case forward. Instead, we try to be as quick on the turnaround as we can. Review what we've been given, point out what's missing, point out what we think is still needed, or ask follow-up questions based on what we've got. When we do that, we find we're in a much better position to push the case forward. If you're on top of your discovery and you've gotten your documents and you've reviewed everything, well, then it's easier to do your witness list and your itemization of damages. You don't have to ask for an extension or push it back. You're more prepared to work with any potential expert witnesses that you might have, because you have all the information for them to render their opinion and typically produce their report, which is usually required. From there, we may have some depositions. I did a video on depositions, and I think they're slightly overused, but they are useful. And sometimes they can be an important part of the document discovery process, is understanding what's there. But if necessary, do some depositions of even fact witnesses to kind of lock them in on their testimony and really find out what their version of events is, so we can help assess the issues. And then push the case along further, right? If there's going to be an opportunity to settle the case, then let's do it. Let's get to mediation. Let's see if we can have negotiations. Let's see if we can find a resolution to the case before everybody spends more money than it makes sense to spend. If that's not possible, or if it isn't successful, then let's move forward if there's any dispositive motions. So it's like summary judgment, things that maybe wrap up certain issues. And otherwise, I want to get to trial. We are ready, willing, and able to try the cases that we have. I've been doing this for 17 years. I've done dozens of bench trials, dozens of arbitration hearings. I've done multiple jury trials. I've done trials to ALJs. Basically, any scenario in which there's a trier of fact and testimony being taken, I've probably done it, and I've had great success doing it. It's something that I found really suits my skill set and my personality, and I really like it. And oftentimes, pushing to get to trial is what drives a settlement. If the other side either knows they're going to lose or is afraid to try their case, nothing better to get that case done than to be ready and willing to go to trial. So our philosophy is, while we try to be cost conscious and deal with the case in the manner that makes sense, once we've decided to pull that trigger and let's go forward with a lawsuit, I want to be relentless to move it forward. Let's get it done. Let's see if we can get the best result possible, and to do that in as timely a manner as possible. And if we're going to do that, it means we have to be the driving force behind the case.